All right, I will call this meeting of the Senate Judiciary Committee to order. Will the secretary please take the roll?
Senator Flores?
Present.
Senator Orenthal?
Here.
Senator Lang? Senator Wynn? Senator Hansen? Senator Krasner? Senator Ellison? Chair Scheibel.
And I am here. We have everybody present. Thank you. We have a couple things on our agenda for today, including a work session. I'm going to start with the work session, and then we'll move on to bill hearings. And we will start with SB 30. I will turn it over to Mr. McDonald to walk us through the work session document.
Thank you, Chair. Jared McDonald, Research Division, LCB. First bill on your work session is Senate Bill 30. This revises provisions governing requests for public information related to parole. It was sponsored by this committee on behalf of the State Board of Parole Commissioners and heard on March 3rd. The bill requires the State Board of Parole Commissioners to disseminate records of decisions regarding parole to any person who requests the bill of a named prisoner. And we do have one amendment proposed, and this was discussed during the hearing, and it was presented by Justice Bell. And that amendment proposes to amend the bill to clarify that justices are prohibited from providing character witness testimony in parole hearings. Thank you, Chair.
Thank you. And I just wanted to make a note that I know that we had some conversations during the hearing about how researchers or academics or individuals working with non-governmental organizations might still be able to get aggregated data from the parole board. And I did have a conversation with the director about it, and they are going to be adding some language into their administrative regulations that would clarify that research requests would still be honored that ask for aggregate information. That was satisfactory to me to alleviate any of my concerns about still being able to understand, you know, the broader workings of the parole board. So I wanted to let the committee know that before I called for any questions on SB 30.
Madam Chair, no questions. Move to amend and do pass Senate Bill 30.
All right, we have a motion from Vice Chair Flores, a second from Senator Lang. Any discussion on the motion? All right, all in favor say aye. Aye. Any opposed, nay. Excellent. The motion passes unanimously, and I will look for a volunteer to give the floor statement. And that volunteer is Senator Lang. Moving on to SB 87.
Senate Bill 87 revises provisions related to forensic medical examinations. It was sponsored by this committee on behalf of the Joint Interim Standing Committee on the Judiciary and heard on February 26th. This bill requires the state to pay for the cost of a forensic medical examination for a victim of sexual assault from the state general fund. And we do have one amendment that comes from Senator Scheibel, and it's in two parts. The first, cap the amount the state may pay to reimburse the cost of an examination and limits total payments to the amounts of funds in the general fund appropriated for this purpose. Additionally, the amendment will add the term medical facility to mean a facility at which a forensic medical examination of a victim is performed. Thank you, Chair.
Thank you. Any questions on SB 87? All right, I don't see any questions, so I would accept a motion to amend and do pass.
Motion to amend and do pass.
From Senator Krasner, and we have a second from Senator Wynn. Any discussion on the motion? Senator Ellison.
Madam Chair, the state, would this go to fiscal or
the question is if there is a fiscal note, and it looks like there is a fiscal note from DHHS of $0. It would have no fiscal impact, so I don't think it would go to the Finance Committee.
good, because it's a good, I don't want to see it go there.
Thank you. I don't want to see it go there either. And with that, all in favor of not sending this to Finance, but amend and do pass, say aye. Aye. And any opposed, nay. Excellent. By unanimous vote, we will amend and do pass SB 87, and I will give the floor statement to the first volunteer, who is Senator Krasner. And that takes us to SB 89.
Senate Bill 89 revises provisions related to firearms. This was sponsored by Senator Pazina and heard at the joint hearing on March 27th. This bill prohibits a person from purchasing, owning, or having possession, control, or custody of a firearm if the person has been convicted in the immediately preceding 10 years of committing or attempting to commit an offense that is a gross misdemeanor constituting a hate crime under Nevada law, or a similar offense under federal, other state, territory, or district law. The same prohibitions on firearms apply if the person has been convicted of committing or attempting to commit certain violent offenses that constitute a hate crime, and each firearm purchased by a person constitute a separate violation. Finally, the provisions of the bill do not apply to a person who was convicted of any of these offenses prior to July 1, 2025, and who owns, possesses, or has under his or her custody control of a firearm that he or she legally owned before that date. And we have no amendments on this bill. Thank you, Chair.
Any questions on SB 89? All right, not seeing any questions, I will accept a motion to do pass SB 89.
Second.
All right, we have a motion from Senator Lang and a second from Senator Orenshaw. Any discussion on the motion? Senator Hansen.
Thanks, Madam Chair. I'll be voting no on this. You guys already heard my feelings on hate crime laws in general. I don't think it's right that we single out some people as being more valuable victims than others. Secondly, this on a misdemeanor or gross misdemeanor statute will allow a 10-year prohibition of a constitutional right, which is extremely excessive. So I don't think you should lose your constitutional rights for misdemeanors or gross misdemeanors. And so I will definitely be a no on this one.
We'll go to Senator Krasner next.
Thank you, Chair. I appreciate the sponsors' thoughtfulness that went into this bill. There are many portions of the bill that I agree with. I'm certainly not in favor of hate crimes. I just think that the penalties are a little bit too harsh, so unfortunately I'm going to have to vote no.
And Senator Ellison, I wasn't sure if you wanted to be.
No, ma'am. I go with my colleagues. We talked about this quite a bit, and there's just too much of an issue, so definitely a no.
Understood. All right. That being the case, all in favor say aye. Aye. Any opposed, nay. All right, the nays are Krasner, Ellison, and Hansen. The rest are ayes. With that, the motion does pass, and I will assign this floor statement to Senator Pazina. And that takes us to SB 350.
Senate Bill 350 revises provisions related to the death penalty. And this was sponsored by Senator Orenshaw and heard on April 3rd. The bill requires a judge, when a judgment of death is pronounced, to issue a warrant that appoints the week the judgment is to be executed. 1, to be not less than 180 days nor more than 270 days from the time of the judgment, or 2, if there is a warrant appointing a week within which the judgment is to be executed in force at the time a new warrant is issued. The new warrant is not to be less than 180 days nor more than 270 days. Thank you, Chair. Oh, excuse me. We do have one amendment, and this was sponsored by Senator Orenshaw, and you can take a look at that on the next page. This proposes to amend the bill to clarify that any district court in any county cannot issue a warrant if there is a pending warrant anywhere else in the state. Thank you, Chair.
Thank you. Any questions on SB 350? Senator Ellison.
Thank you, Madam Chairman. I'm going to be a no on this, and the reason is we're allowing too many people to have so many different trials, and it keeps going and going and extending this back, and the ones that suffer are the families. So I don't believe in going forward with this bill because of the time and it extends it. So I'll be a no.
Understood. All right. I would accept a motion to amend and do pass. And we have a motion from Senator Wynn and a second from Vice Chair Flores. Any discussion on the motion? Please, Senator Wynn.
I would just urge my colleagues to support this bill. We are constitutionally mandated to provide these due process protections for these individuals that have been accused of crimes and are going through this like appellate process. I realize it can be slow and that can be traumatic, but I think some of the revisions in this bill will actually lead to quicker outcomes for all parties involved. So that's all I'd say.
Thank you. Senator Hansen.
Thanks, Madam Chair. No, I'm a definite no on this. For the idea behind this, as I understand it, it will simply extend out further due process that is being used right now. You know, we had a brief discussion on the death penalty. It hasn't been used in Nevada since 2006. I really do question whether or not it is a deterrent anymore. And we've basically got almost a cottage industry of attorneys that specialize in making their living off of these constant appeals that never end. So, you know, you and I had a brief discussion before. I wouldn't be surprised that maybe even I would support the idea of abolishing it. I did talk to the to the district attorneys, and they said, hell no, they don't want to, because their theory is that then that cottage industry will simply go to figuring out ways to eliminate the concept of life without possibility of parole. But nevertheless, I don't think this really does anything other than extend the process out even further than it already is. And as Senator Ellison mentioned, the real problem in this whole process of all these endless appeals is it absolutely must be crushing for the families that expect the verdict to be carried out at some point. And it is always being pushed out, and they literally are being forced to relive and in some cases, retestify even in these hearings, and it's just inhumane and wrong to do that to the victims of the crime. So if we're going to abolish it, fine. If we're not going to abolish it, though, we need to come up with a system where this endless appeals process has some reasonable limitations. This bill goes the opposite direction of that, so I'm definitely going to vote no on this bill. Thank you, Madam Chair.
Thank you. Go ahead, Senator Orenshaw.
Thank you, Chair. And just to respond to my colleagues, Senator Hansen, certainly I'm biased. I'm sponsoring the bill, but there was testimony that I earnestly believe this could lead to less litigation. There was testimony that the status quo doesn't benefit the person who's been sentenced to death. It doesn't benefit the family of the victim, and it doesn't benefit the stakeholders. You know, we heard testimony from NDOC that very often under the current status quo, the preparation that's required, the readiness to even try to carry this out, it's not available. It's not there. There were references to the prior testimony of the prior director, Daniels, as to his statement that they're not ready under the status quo. There are many issues that have to be considered, and certainly from the way I understand it, the status quo doesn't benefit anyone, and I believe that this small change could lead to less litigation, and I certainly don't believe there's anything in this bill that would lead to more litigation. And that's certainly my belief, and I believe that was the lion's share of the testimony that we heard during the hearing.
All right. Any further discussion? Not seeing any further discussion. All in favor of the motion on the floor to amend and to pass SB 350, say aye.
Aye.
And any opposed, nay. All right. The nays are Senators Krasner, Ellison, and Hansen. The motion to amend and to pass carries, and I will assign the floor statement to Senator Orenshaw.
Senate Bill 407, next bill on your work session. It revises provisions related to legal representation for indigent persons. It was sponsored by this committee on behalf of the Joint Interim Standing Committee on the Judiciary and heard on April 2nd. The bill creates the Office of Alternate State Public Defender within the Department of Indigent Defense Services to counsel and defend indigent persons under certain circumstances, including without limitation if the county public defender or state public defender is disqualified or otherwise unable to provide representation. The bill also creates the Office of Post-Conviction Counsel within the department to prosecute appeals and other post-conviction remedies on behalf of indigent persons under certain circumstances. And we have no amendments proposed for this bill. Thank you, Chair.
All right. Any questions on SB 407? Senator Ellison. Understood. Anybody else? All right, not seeing anything. I would accept a motion to do pass SB 407. All right, we have a motion from Senator Nguyen. We have a second from Senator Lang. Any discussion on the motion? Not seeing any. All in favor, aye. Aye. Any opposed, nay. By unanimous vote, we will do pass SB 407. I will assign the floor statement to a volunteer. Anybody? All right, Senator Wynn. And that concludes our work session for today. Excellent work, everybody. Thank you for your time and consideration. With that, I will now open the hearing on SB 62. I do want to make sure that our members are looking at the proposed amendment from the Attorney General's office. It has yesterday's date on it, 4/7/25. It's about 2 pages long. And if anybody doesn't have it, it is on Nellis, or we can get you a copy. So with that, I will turn it over to you to give us your presentation on the bill.
Good afternoon, Chair Scheibel and members of the Senate Committee on Judiciary. For the record, my name is Mike Morton, M-I-K-E-M-O-R-T-O-N, Special Assistant Attorney General at the Nevada Attorney General's Office, and I'm here today to present Senate Bill 62. For the purposes of my presentation, with the Chair's permission, I will use the proposed amendment submitted by the Attorney General's Office. This committee has heard several times this session that Attorney General Ford uses 5 guiding principles in his administration of justice: constitutional rights, criminal justice and reform, consumer protection, client service, and community engagement. All of our work at the Attorney General's office, in the courtroom, here at the legislature, and out in the community always serves at least one of these principles. Here, Senate Bill 62 ensures that the needs of victims are heard and met in our pursuit of criminal justice and reform, while also addressing their constitutional rights to live in their communities free from hate based on constitutionally protected attributes. As proposed in the amendment, SB 62 would become just 3 sections. The proposed new Section 1.3 adds a new section to Chapter 217 of NRS, which currently governs the Fund for the Compensation of Victims. The new section would authorize payment from the fund to victims of hate crimes, specifically for those victims who experienced property damage during the commission of the crime. The new Section 1.6 in the amendment document amends the definition of victim in NRS 217.070 to include those who are subject to a crime where the hate crime enhancement has been imposed pursuant to either NRS 193.1675 or NRS 207.185. This definition of victim is what the administrators of the fund use for eligibility determinations when reviewing applications for compensation from the fund. Finally, Section 5 as drafted in the amendment would appropriate money for 3 different funds or offices. $60,000 in the next biennium to the Fund for the Compensation of Victims, $40,000 in the next biennium to the Office of the Attorney General, and $1 million in the next biennium to the Contingency Account for Victims of Human Trafficking. The $60,000 to the Fund for the Compensation of Victims would specifically be used to compensate victims of hate crime for the purposes described in Chapter 217, both in existing statutes that address compensation for injuries suffered by the person and the remediation of property that I discussed when explaining the new Section 1.3. The $40,000 appropriated to the Attorney General's office would be utilized by our victim advocates to provide support and resources to victims of any crime prosecuted by the Attorney General's office. In 2023, this legislature funded 2 new victim advocate positions within the Attorney General's office, which were brand new positions to support victims of crime, both during the pendency of a criminal case and afterwards, where our victim advocates aid in identifying resources for these victims that help them rebuild their lives. While our victim advocates have done great work in this area over the past 2 years, there are often large gaps in victim resources, especially while a criminal case is ongoing, that these funds would help close. The $1 million to the account for victims of human trafficking would be used for those statutorily authorized purposes of that account to provide programs and services to victims of human trafficking. This appropriation was requested by the Nevada Policy Council on Human Trafficking through Senator Pazina, and our office was happy to use Senate Bill 62 as a vehicle for that amendment. That completes my overview of Senate Bill 62 and would be happy to answer any questions that the committee may have.
Thank you so much. Questions from members of the committee, starting with Vice Chair Flores.
Thank you for the presentation. This is questions just more broadly. Do you have any data on how many victims per year you're getting that would fall into these categories? And it's all good if you if you didn't have that data on you. I was just curious to know how many humans we're talking about.
Mike Morton, for the record. I actually do Vice Chair Flores. I have a couple years going back. The last full year of data in 2024 statewide with 160 victims of that where the defendant was charged with the hate crime enhancement either under either of those two statutes that I had referenced. We had 85 in 2023, 98 in 2022, and 110 in 2021.
Thank you. And could you walk us through what the relationship is like presently when you identify these victims and you're working through these cases? Obviously, we're setting up a fund, help them. Just walk us through how essential this money is and how it's used, and just, maybe pick one scenario that you could walk us through it.
Mike Morton, for the record. Obviously my examples will be specific to the Attorney General's office, not those that are pursued by our local district attorneys. So the way that the fund for compensation of victims, the existing fund works, is that in that definition of victim, there are certain people that are eligible to apply to this fund for reimbursement for injuries that were a direct result of the crime. But that fund is only applicable to those victims at the conclusion of the criminal case. And at the Attorney General's office, we have found that the victims, there are certain needs that the victims present that would not only aid those victims in continuing their lives at that point, but also aid our office, because oftentimes those victims are witnesses. And so a lot of what our victim advocates would envision the money being used for that would be appropriated to the Attorney General's office under this bill: emergency housing and shelter, transportation services, to medical appointments, therapy appointments, court travel, relocation services if the crime being prosecuted presents some safety concerns for the victim to be testifying, in public in court. And so those are some of the needs that our victims have presented, and that our victim advocates, have really seen during the pendency of criminal trials.
Thank you, Madam Chair. Thank you.
Other questions from members of the committee? Senator Hansen.
Thanks, Madam Chair. I actually have several. We've had a huge spike just recently of people carving swastikas into Teslas. And there's been a very intense hatred towards Donald Trump, to the point where people like myself are uncomfortable wearing a MAGA hat in public because we've been threatened with physical violence. Does anything that's happening to people who own Teslas, who are getting swastikas carved into them, are they protected at all, or is there any kind of enhanced penalty for them, for their damaged vehicles and things like that, for this type of hate?
Mike Morton, for the record. Senator Hansen. Currently, no, and that is what Section 1.3 in the amendment document seeks to address to a certain extent. Currently, the Fund for Compensation of Victims does not only covers, I'll call them damages to the person, where the person was, physically injured, mentally injured, and those costs can be covered. Currently, property crimes are not covered by that fund, and so Section 1.3 would add a certain level of compensation that could be applied for remediation of property.
Okay, but let's talk about if you have damage to the property of a person. Now, same exact scenario, if Elon Musk was Jewish and people were carving swastikas into those vehicles, would that possibly raise the bar to a hate crime?
If the prosecuting attorney in that jurisdiction did seek to add the enhancement under 207-185, and that prosecutor can prove that under your hypothetical that image was carved into property based on that person's, in this case, religion, then yes.
Okay, so in other words, if you do the exact same crime to the exact same vehicle, but simply because of a difference of either the religious or whatever characteristic, that in one case it's an enhanced penalty, but the exact same act for anybody else would not be an enhanced penalty. Is that what you're saying?
Mike Morton for the record. What I am saying is that under either 193.1675 or 207.185, there are certain classes that constitute hate crimes, and that if the prosecuting agency can prove that that damage to the property was done because of hate that is listed out in those two statutes, then the enhanced penalty would apply, and under this bill, that victim would be eligible to apply for compensation to remediate that property.
Okay, no, that's my whole point with this whole hate crime thing. Here you are acknowledging that it's hate in both cases, but because you're not a member of the specified class, you don't get any enhanced penalty, even though you have the exact same acts done to you, the exact same types of hatred described and directed in your way, and physical damage to your property because of an intense form of hatred of Elon Musk in this case, or Donald Trump, but there's no enhanced penalties in that case. But you can have the exact same thing, and if the individual was one of the protected classes, then you have an enhanced penalty. Totally wrong. If hate is wrong, it's always wrong in every case. And to single out certain people is like, well, these are special classes, so when you do a violation to them, they should have an enhanced penalty, means all the other people that don't fit in those classes are somehow, what, second-class citizens? And therefore they're not going to have the same level of protection of the law? I mean, we're supposed to have equal protection of the laws for everybody. So got a real problem with that. Last question, though, and that is the definition that you're striking out, as used in this section, gender identity expression has the meaning ascribed to it. We had a brief discussion about it. I've had conflicting comments. Gender, if a misogyny, I should say, is misogyny considered a hate crime under current Nevada law or under this law? Because we have some, if a man knowingly attacks a woman because she is a woman, my understanding is it's not currently considered a hate crime. But Mr. Wilkinson and I had a discussion on it. What is your understanding of that? Or vice versa, if a woman attacks a man because she hates men. I don't know, the misogyny, I don't know what the term is for women that hate men, but it must be something like misogyny, only I don't know what the word is. Funny, we don't even know the word. It shows kind of the bias in our own thinking. But anyway, is misogyny considered a hate crime under Nevada statute now? If I attacked a woman because she was a woman, is that a crime currently? Or an enhanced crime, I should say?
Mike Morton for the record. I can point you to the statistics in 2024, the publicly available statistics that are aggregated for the entire state. As I mentioned before, the hate crime enhancement was applied 160 times statewide. When that number is broken down by the type of bias, gender bias was used twice.
I know, but gender bias, as I understand it, is people who attack people who identify as they're biologically male and they identify as female, or along those kind of lines. Is that misandry? Thank you. Now we know. So anyway, it's kind of funny how we don't even know that one. Now that occurs too. So right now you've had two cases that you said are gender identity hate crimes. Is that what I just heard?
That's incorrect. I said gender bias. Gender identity bias was used once in 2024, so they are separate.
Okay, so because that's really strange, because there's a whole lot of cases of men attacking women and acts of violence towards women who clearly were motivated because they were mad at women. So kind of wondering why that category isn't much higher. When I did some research on this, one of the reasons, as I understood it, gender is not included is because it would almost make hate crimes so common as to lose any distinction to them. So anyway, now I got some real issues with this whole concept of making certain classes of citizens somehow more valuable victims than others. Everybody who gets attacked for any kind of hate should be treated uniformly in our system of justice. equal protection laws, but we've constantly been escalating this. Certain categories are singled out for special enhanced penalties, which means those that aren't in those categories are second-class citizens is how I look at it. So thank you, Madam Chair.
Of course. Senator Ellison.
Thank you, Madam Chair. And I didn't get to talk to Ira about this, but I do have a problem. When they had the crash and runs, they go into these big stores and there are large numbers of people, and they go in and they usually beat the people that's in the stores, either with bats or sticks or whatever they can get their hands on. But they actually do a lot of physical damage to these people. But yet they're not tried as a hate crime, and they're not going after the people that attacked them under a hate crime. Because you go back and look at the statistics, most of the people in the store working were white, and the people that broke in were big gangs. And I think that's wrong. And when I read this, that's what I'm thinking of. And look how many of them's been. I mean, look, Vegas, they've had them all over the country. But, you know, you're singling out groups. I believe different. I believe God created everybody equal, no matter what you wear, what you do. No such thing as color. But this separates everybody, I feel. I believe if groups go in massive numbers and beat people for robbery, they should be tried as a hate crime or anything else that you could try them for. But they're not doing that. So that was a problem I had with this bill, and I just think it's ridiculous. I just believe everybody's created equal under God, and that's the way it should be, and not single them out. Thank you.
Other questions from members of the committee? I actually have a couple questions as well, kind of along the same line of questions about the hate crimes, and I think it's a very interesting discussion, and part of the reason that I find it interesting is that I'm not sure that what happens in practice always reflects what we expect to happen with these with these bills as we discuss them. And so I think you said that last year there were 160 people who you identified as victims of hate crimes, right?
Mike Morton, for the record. I apologize if I misspoke. 160 individuals were charged with the hate crime enhancement.
And how many were convicted with a hate crime enhancement?
I'm sorry, these statistics are at the finality of cases. So it was 160 convictions of underlying crimes that were the hate crime enhancement was added statewide.
Do you have a list of those convictions?
Mike Morton, for the record. The Nevada Crime Statistics website aggregates the data in different ways. If you're looking for like a list of the actual cases, I'm sure that could be obtained. It would take a bit to go to all the different jurisdictions and obtain those cases, but the Nevada Crime Statistics website does break it down, type of, of those 160, how many were property crimes, how many crimes were against the person, how many of, and then a aggregate breakdown of the victim of that hate crime also.
And see, that's exactly my concern, is that the Nevada Crime Statistics website is supposed to be aggregating this data, and I talked to the Nevada Department of Sentencing Policy about this, and I understand that they don't provide the data to the Nevada Crime Statistics, and so I was just looking at this, and I mean, I would like to see a list of the cases, is what I'm saying. I find it hard to believe that 116 people had judgments of convictions filed in cases in Nevada with a hate crime enhancement in the year 2024. I'm especially looking at the Nevada Crime Statistics website when there were only 105 in Clark County, supposedly. So that means that there were 55 people across the 16 counties outside of Clark that were convicted of hate crimes, and can you name one of them? Can you name one case?
Pardon me, Mike Morton for the record. I cannot name one case. I'm very happy to get that information for the committee. The way that these statistics are reported to Nevada Crime Statistics is from each individual jurisdiction. So the Attorney General's office, the 17 counties, the various cities and municipalities, the Department of Corrections. So there are a number, a plethora of reporters to that aggregation. But I'm happy to get a number of those specific cases for you and for the committee.
Thank you. I would appreciate that. And I'm not disputing that we should be providing compensation to victims of hate crimes. I'm just concerned that here's the reason I'm concerned about it. I'm not trying to put you on the spot. I'm not trying to, impugn the integrity of any of our law enforcement agencies or prosecutorial agencies. My concern is that, and this is kind of to my colleague's point, let's say across the state you have a number of Jewish folks who are experiencing hate, who are, victims of violence against them because of their religion. I think that there are certain communities where the person who perpetrates the crime against them is more likely to be convicted with the hate crime enhancement, and other places where they're more likely to be convicted without the hate crime enhancement. And so you might be setting up on accident this inequality where if you happen to live in a jurisdiction where the hate crime enhancement was sought and achieved, you get the $1,000 to repair your home or your car or your personal possessions, but somebody else who's exactly similarly situated, because the person who perpetrated the crime against them enters some different kind of negotiations, you aren't entitled to the same compensation. That is my concern. And it could be alleviated by knowing that the hate crime enhancement is, in fact, an appropriate, what's the word I'm looking for? It does correlate one-to-one with the perpetration of hate crimes. They are being convicted of hate crime enhancements. And then I just wanted to clarify also that in Section 5 of the bill, I appreciate this is a series of 3 different appropriations. Is that correct?
Mike Morton for the record, that is correct.
Okay. I don't have any further questions. Okay. I think Senator Hansen has a question for legal, so we really do appreciate you answering all of our questions. I know I kind of put you on the spot there, and you're not the crime statistician for the state of Nevada. And I'll turn it over now to Senator Hansen and legal counsel.
Thanks. My question for legal is actually in Section 4, where we're setting up an account that is going to go in the state general fund, but the Attorney General should administer the account. I've been watching this tendency growing where law enforcement agencies are actually being able to keep the fines or penalties in certain circumstances. The problem I have with that is it kind of gives an incentive. Like we had situations where, I forget what it's called, but if the police pull you over and they find you, you have a briefcase in your trunk with $50,000 in it, that the law enforcement agencies are able to keep those. I'm just kind of wondering, is this common in Nevada law? And is there any question about the danger of setting up an account like this? Are there other accounts that are like this where you have them actually controlled, even though they're in the state general fund, by a law enforcement agency? I'm sorry, that's probably a long-term question. Not fair to ask you right now, Brad, so if you want to get back to me, I got it.
Thank you, Chair. That's kind of a hard question. I really wouldn't know off the top of my head.
I'm shocked.
I don't know. I don't know if Mr. Morton would have any idea about the AG's office specifically, but I'm not really aware of law enforcement managing different accounts. I don't think it's entirely rare for the Attorney General to do that. I believe there are some other accounts managed by the Attorney General's office, but maybe Mr. Morton would know better than I do.
Mike Morton for the record. I will start my answer to that question by noting that the amendment deletes section 4.
Oh, I'm sorry.
The first line of the amendment is to delete sections 1, 2, 3, 4, and 6 of the bill. And even if the account were still being sought to be created, that account was specifically just for general fund appropriations to aid victims of crime. No fines or fees would have gone into that account. Thank you.
Okay, well, thank you. My question then superfluous. My apologies for not seeing the amendment. Although that is something that the committee may consider in the future. There are several examples where I know of law enforcement being allowed to keep certain things that if somebody's convicted, instead of it should go to the state's general fund or into some sort of a fund that doesn't create some sort of a kind of a perverse incentive for them to try to prosecute people based on potential financial rewards. I don't think we should ever encourage that. And there are several examples I know of right now where law enforcement agencies do get to keep certain penalties, especially financial things that they find during their investigations. In my mind, that should go to the state's general fund. I do not want to encourage any kind of law enforcement issue where they actually may have an incentive to go after somebody because they get to keep $50,000 that they found in the trunk of some drug dealer's car or something like that. So anyway, thank you, Madam Chair.
All right. Not seeing any further questions. Thank you so much for your presentation. We will move now into testimony in support of SB 62. Anybody wishing to give support testimony is invited forward now here in Carson City or down south in Las Vegas. You just turn on your microphone.
Is it on now?
The lights are red.
I'm sorry. I apologize.
That's okay. Go
Good
ahead.
afternoon. My name is Brenda Sandquist, BRENDASANDQUIST. Thank you, Madam Chair and members of the committee for hearing our support today. As the executive director of Exquisite, which is a nonprofit here in Carson City, I wanted to personally thank you for the funds that we received from the Human Trafficking Contingency Account allocation from the last session. This fund provided much needed support, and we were able to provide for the victims and survivors that we serve personally. On behalf of those victims and survivors of human trafficking in our state of Nevada, I am requesting consideration to be made to replenish those funds in this account to support the continued trauma-informed care that victims and survivors really need. The goal that Exquisite and all the survivor service providers in our state is to help survivors move forward on this journey to freedom from the hate-filled atrocities that they have to endure on a daily basis. These funds are vital to continue to serve the victims and survivors here in our state. Thank you.
Marco Rauda, MARCO RAUDA, representing the Nevada Policy Council on Human Trafficking. I want to thank the chair, the committee, and thank the AG's office for bringing this bill forward. I want to continue to, and I also want to thank this body for the continued commitment to victims, especially victims of human trafficking, and helping these humans find a way out of their current lives and helping them in their new path forward. So hoping that you guys can pass and help these victims. Thank you.
Thank you so much. I don't see anybody coming forward in Las Vegas, so we'll go to the phones, please, for testimony in support of SB 62.
Thank you, Chair. If you would like to testify in support of Senate Bill 62, please press *9 now on your phone to take your place in the queue.
Good afternoon, Chair Scheibel and members of the committee. My name is Lauren Boitel, Laurenboitel, and I'm the co-founder of the Nevada Policy Council on Human Trafficking. I'm here to express our strong support for SB 62, particularly the amendment to allocate $1 million from the general fund to the Victims of Human Trafficking Fund. This fund is essential to continue the critical work being done across our state to support survivors and enhance our human trafficking response system. First, I want to take a moment to applaud Senator Scheibel for her leadership in securing this funding in the 2023 legislative session through SB 389. The funds have been well utilized, benefiting both service providers and law enforcement throughout Nevada. Organizations like Awaken, the Embracing Project, Exquisite, as you've heard from, and Washoe County Sheriff's Office have made significant strides in supporting survivors of trafficking, from providing trauma-informed case management and advocacy to expanding direct services in the state. These funds were used by these entities to expand trauma-informed services for adult and youth victims of sex trafficking and commercial sexual exploitation with crisis intervention, case management, and education, as well as vital support like medical care and survivor advocacy. 291 total clients and victims were served by these funds in Q1 and Q2 of fiscal year 2025 alone. These are just a few examples of the immediate and crucial work these funds support for our most vulnerable Nevadans, but they also underscore a larger need. The funds allocated in SB 389 are already nearly exhausted, and continued support is crucial. Replenishing the Victims of Human Trafficking Fund through SB 62 will allow these organizations and many others to continue their important work, protect victims, and build on the momentum we've seen in combating human trafficking in the Silver State. At the Nevada Policy Council, our mission is to advocate for just and equitable policy solutions, and funding like the allocation in SB 62 is a vital part of that effort. It enables the state to not only support survivors, but to demonstrate a commitment to tackling human trafficking as a critical social issue in Nevada. We firmly believe that this funding is necessary investment in the safety, dignity, and future of Nevadans. Thank you to the AG's office for your work on this bill, and thank you, Chair Scheibel and members of the committee, for your time and your continued commitment to fighting human trafficking in our state. We urge your support for SB 62. Thank you.
Sheriff, public line is open and working. There are no further callers to give support testimony at this time.
All right, thank you. We will move to testimony in opposition to SB 62. Anybody wishing to give opposition testimony in person is invited forward now to do so. Please go ahead.
Good afternoon, Madam Chairman, members of the committee. My name is Janine Hansen. I'm the state chairman of the Independent American Party. We were here to testify against the original bill, and we see that Section 1 and many other sections have been deleted. I would just make a couple of comments. When I read Section 1, and it talks about substantially annoy or inconvenience another person, I thought about growing up with 4 brothers and how many times they had done that to me. So I think that definition was very vague, and I'm very glad it's been taken out of the bill. The other thing we were concerned with was thought crimes, all hate crimes, and this as a bias crime includes thought crimes. And the bill also mandated that information regarding crimes to be reported to the Nevada Central Criminal Record Depository and to the FBI, which is troublesome. Those reports to the Nevada Central Repository of Crime and Conviction and FBI pave the way for gun owners' convictions under SB 62 thought crimes to lose their Second Amendment rights, because those hate crimes come within a 10-year look-back period at any bias or hate crime convictions anywhere in the country in the past 10 years. The other issue we have with this continued move towards bias and hate crimes is that people can be charged for things like psychological distress. Equal enforcement of the law is thrown out with bias window and special classes becoming more equal than others. The 14th Amendment's Equal Protection Clause prohibits states from denying any person within its jurisdiction the equal protection of the law, is ensuring equal treatment under the law for its citizens. We appreciate the fact that these things have been deleted from the bill, and we wanted to make our position on the original bill known. Thank you.
Tanya Freeman. I agree with what Janine Hansen has said. I also agree with what Senator Hansen, Senator Ellison's comments. And, you know, as the original bill, if I'd called the law enforcement on any of this, I'd be in court today, tomorrow, and next week. To me, this is crazy.
All right, I don't see anybody else coming forward in Carson City or Las Vegas to give opposition testimony. So we'll go to the phones, please, for opposition testimony on SB 62.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then we will go to testimony in neutral on SB 62. Anybody wishing to give in-person neutral testimony is invited forward now. I don't see anybody coming forward, so we'll go to the phones, please, for neutral testimony on SB 62.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then that concludes testimony on SB 62. If you'd like to make any closing remarks, please come on down.
Mike Morton with the Attorney General's Office, for the record. I'd like to thank the chair and the committee for hearing this bill, and also just remind the committee that nothing in this amendment changes, restricts, or expands the current hate crime statute. This bill would now give more opportunities for victims of crime to receive compensation in order to rebuild whatever was lost. This committee before has been frustrated with how restitution is never paid. This in no way will make somebody whole, but it is a start. And I'll also remind the committee that for the hate crime enhancement to be applied to a crime, a prosecutor must show that but for the person's status, the underlying crime would have never happened. So this hate crime enhancement is not attached to everything just to see if it will stick. The prosecutor must prove but for that hate, the crime would not have happened. Thank you.
Thank you so much. I will now close the hearing on SB 62. That takes us to the last item on our agenda for today, public comment. Anybody wishing to give public comment is invited forward here in Carson City or down south in Las Vegas, but I don't see anybody coming forward. So we'll go to the phones, please, for public comment.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then. That brings us to the conclusion of our meeting for today. We will be meeting again tomorrow, same time, same place. And until then, we are adjourned.